in the matter of H, a child.
Good morning,
yes, Mr.
Your
Hatton.
Lordships. I'm Mr. Hatton, appearing on behalf
Yes.
of the appellant mother. The first respondent, local authority, is represented by Miss Roach.
Yes.
The second respondent's father, his attendance has been excused, as has those of his legal representatives by the court.
Yes.
And the third respondent is the child, represented through his guardian, Miss Fox, and counsel, Miss Gleister-Young.
Yes. Well, we've read the skeleton argument. We have read the judge's order under appeal and her previous order, and we've also read her judgment in relation to the children. We think this is a relatively short point, so you can take it shortly.
Thank you, my lord. Certainly it is a focused issue, and I understand that no party opposes the appeal, although the guardian does raise some questions. Yes. So what I intended to do was just address some of those questions raised by the guardian within her skeleton argument. The first is that the guardian queries whether the decision had already been taken to rule out the appellant as a realistic option to care for her child at the final hearing, which went part heard in February. That assertion is not accepted, while the guardian notes that within her case summary for the April hearing, counsel on behalf of the guardian asserted that the appellant had been ruled out in February. It does appear in my submission that that was an error. When reading the judgment from the February hearing, it's clear from that judgment in my submission that the judge firstly was considering an application for expert assessment made by the appellant rather than a query about whether to rule her out as a realistic option or not. And there is no reference to the what one might expect from a legal test to rule the appellant out in those circumstances, such as the adoption welfare checklist. And
there's no appeal against the judge's refusal to order a further parenting assessment?
There is not. No, my lord.
There was also talk at that stage of another family placement, wasn't there? Yet another one.
Yes.
But that came to nothing, as I understand.
That's correct. So
that's a further argument, I suppose, on your side.
It is.
Given that door was open, however narrow the gap in the door, it was still the case that no decision could be taken at that stage to rule out the door.
Certainly. And so as things resulted at the end of the February hearing, the mother's position was that she still sought to care for her child, either by herself or with the family support, which the judge directed further assessment of that second option. In my submission, it's also noteworthy that there is no inclusion within the order from February that the mother had been ruled out in that hearing or the basis for that. There is, however, inclusion within the order from the April hearing that the mother had been ruled out. So it's clear from those two orders that the mother was not ruled out until the April hearing.
And there was no discussion of this at all at the April hearing. Is that right?
No, my lord. So submissions were made. It was a 1-hour case management hearing to deal with a number of issues, but perhaps most pertinently,
your clients, whether there should be a suspension of your contact.
Correct, yes. And that took up, as you can probably imagine, the majority of that hour. It was submitted on behalf of the mother that she remained a realistic prospect to care for her child. That wasn't challenged by the court or other parties, and there was no further discussion. The first that the mother became aware that the court was contemplating ruling her out as a realistic option was when judgment was given on the suspension of her contact under the transition plan. She was therefore taken by surprise in my submission.
Yeah.
It denied the mother an ability to put forward any representations, either in oral evidence or through submissions made by her counsel. Of course, at that stage, the court had heard evidence at the February hearing from the local authority. There was a social worker and a parenting assessor who gave oral evidence, and it's right that they were challenged on behalf of the mother in cross-examination.
Not the guardian. You hadn't heard the
Not the guardian. Hadn't heard from the guardian. The mother herself hadn't been given the opportunity to give oral evidence, as had been the expectation at the February hearing. And so the consequence of that is that although the local authority were challenged through cross-examination on behalf of the mother, of course they can't speak to the mother and her case. At that point, the mother was, although living with the father, she was asserting a case that she would be able to separate geographically from him and maintain boundaries from him. That is included within her written evidence. That was not challenged at the February hearing because it went adjourned part heard. So the court had not had an opportunity to hear the mother's response to that. And it seems as the court has therefore summarily determined the mother's credibility, insight and ability to put in those boundaries without the mother having an option, having the possibility of answering any scepticism around her proposals. And of course, that is a subjective decision that the court can make. It's not an objective one. For example, if you have an expert who might recommend a set period of time that's needed before change can occur, one often thinks of the drug and alcohol cases where 12 months might be given as a time period. That might be challenged, that 12-month timescale, under cross-examination, and the court finds that notwithstanding those challenges, the expert's evidence stands up, so you've got a clear 12 months. That is an objective determination that the court might be able to make without hearing evidence from the parent if it's accepted, if the use is accepted and there's no factual dispute. In this matter, in my submission, it's very different because it's a subjective assessment of the mother's credibility, her insight and ability to put in place boundaries with the father. And that could only be determined once hearing her evidence and her answering any scepticism that the court might have on those points. The Guardian queries whether the appellant ought to have addressed the issue of being ruled out as a realistic prospect at the case management hearing in April, notwithstanding that it was not a matter that any party was inviting the court to rule on or determine. In my submission, that suggestion goes against the overriding objective, thinking particularly about dealing with cases efficiently, and also the President of the Family Division's guidance on making every hearing count, because the result of that would be that every hearing would result in unnecessarily lengthy submissions being made on all matters that might be put in issue, even at a case management hearing, as this was.
But your fundamental point is that what the judge did wasn't fair.
Yes, my lord.
It really just boils down to that, doesn't it?
It does. And that is the crux of the appeal, and very squarely the appeal stands or falls on that point.
Nobody denies it, everybody accepts it was irregular.
Yes.
And there may be an issue as to whether it was so irregular as to lead to injustice. That seems to be the issue for this court.
Yes.
And you've kept your case pretty clear.
Yes.
And you hadn't been given any advance warning that this was on the agenda for the 1 hour hearing?
Not at all, my lord. In fact, the Guardian, in her case summary, had thought the decision had already been made, so that wasn't raised as an issue on behalf of the Guardian to be determined. The local authority didn't seek to rule out the mother at that hearing, particularly, I think, given where we were with the evidence, and there'd been no notice from the court.
It seems as though the judge may, this is speculating because we don't have a judgment addressing this point, the judge may have thought that what your clients said about Mr. and Mrs. I'm going to call Mrs. A, the couple who are now looking after the child, it indicated that she was supporting that placement, and because she was saying anything but adoption. Is there any scope for it being said against you that the judge was entitled to take that as indicative?
Well,
that your client was conceding the point?
The mother certainly was against adoption, would have not wanted to rule out or put in place any hurdle to an alternative placement other than adoption being successful. However, as things stood at the April hearing, the mother very clearly put herself forward to care for the child herself, and as a secondary option would support the child remaining in the family placement. At that stage, and in fact as we stand here today, there isn't a full assessment of that family placement. So it was difficult, if not impossible, for the mother to fully throw her weight behind that family placement in circumstances where it's unknown what that assessment may have thrown up. The points, I think, are set out in the skeleton argument. I'm not sure there's much else that I can add, unless there are any questions that your lordships might have.
If we were to allow the appeal, what should we do?
We would invite the court to list a case management hearing
For the same judge or a different judge?
for a different judge. If the appeal is successful, the mother would argue that the decision that was made in April was predeterminative of a central issue. The difficulty with putting it in front of the same judge is that if the family assessment is negative and the mother had put herself forward to care for the child herself, she will worry that it's been predetermined
Yes.
at the April hearing, which would lead to further delay if there's then a recusal application made.
All right.
So this is for Brighton. So this is Judge Bedford. Is he the?
The DFJ, yes.
Okay. So this case is listed for it's 2 months. Whilst this case is listed in August, we might be able to get another judge for that date.
Yes, so the next hearing.
Understandably concerned about any further delay.
Yes, and certainly the mother wouldn't want to cause any unnecessary delay. In fact, listing in front of another judge is with the idea that it might well save delay further down the line.
Why would it not be possible for us just to keep the date and list it for directly be listed before another judge? Why do we need another case management hearing, do you think?
Well, the suggestion of another case management hearing would have two purposes. Firstly, it would enable the judge who is then going to try the case on the 21st of August, because it is listed as a final hearing at the moment.
It's part heard, isn't it?
As part heard, to make any further case management decisions that they might need to take. It could also be used to consider the mother's contact, which I know there is, I'm told by the local authority today, there is a review that's going to take place and it's due to recommence with the child on the 4th of July, which gives us some 2 weeks.
So the judge said there should be a 10-week pause in the contact, but did say that there could be that could be foreshortened in the circumstances. And
Yes.
we're 10 weeks. No, we're not. We probably are 10 weeks.
Probably about that, yes.
Okay.
And there might not be much that we can achieve in the time before the contact's due to recommence on the 4th of July, but certainly I know the mother would want that contact to recommence as soon as possible. One of the bases, of course, for the decision that Judge Early made in suspending the contact for such a long period of time was, and I accept there are many considerations, but one consideration was that she ruled the mother out as a realistic prospect. And so it's on that basis that we ask the local authority, if the appeal is successful, to try and bring forward contact as early as possible.
So the case management first open date after what date do you say?
I would say available.
Okay.
Very much, Mr. Happen.
Thank you, Madam.
Yes, Ms. Roach.
Well, thank you for your indication that you've read all of the skeleton arguments of the parties. What you'll see from the local authority skeleton argument is that we don't take issue with the appeal in terms of the way it is put regarding procedural irregularity. I wasn't trial counsel in either February or in April, but I do have a very detailed note from trial counsel who was. And what I can be clear about on behalf of the local authority is that it's not our understanding that the mother was ruled out at the February hearing. At the February hearing, the mother had once again come up with an alternative in terms of placement. You'll see that the history of this case is that the mother has come up with a number of alternatives which haven't come to fruition. This alternative was that she was going to care for the child with the support of family members. That hasn't come to fruition, and it hadn't come to fruition by the time of the April hearing. And the judge had given, as I understand it, a very clear indication if it hadn't come to fruition by the April hearing, she wouldn't be giving the mother any further opportunity to put that forward as a possibility. So at the April hearing, we were left with a 1 hour hearing where we were looking at the issue of contact, the mother's contact in particular, and we were looking at the timetable for the placement of the child with couple R. As one can well imagine, that hour was taken up pretty much fully with argument around the suspension of the mother's contact. What the local authority says is that we don't fully accept that the time frame that the judge gave about the suspension of the contact was around her ruling the mother out. There's practice in Surrey, in Sussex, and I don't know whether this is national practice or not, but that a parent's contact is suspended whilst the child moves to a placement such as this, to allow a settling in period, to allow the child to the child's attachment to their parent in that contact centre, in that venue, to be paused, to allow there to be full concentration on the placement that they are moving.
I think it's commonly done. It's not, as it were, a rule of thumb or a practice, but it's commonly done, particularly with children of this age,
Yes.
who have, and this baby was moved to foster care, has been in the same foster care since discharge from hospital, 2 days. So it has formed an attachment at what would then have been 7-8 months. So it's breaking that attachment,
Indeed.
forming the new attachment.
Yes. And although, of course, it's understandable that the mother resisted her contact being paused in the way it was, the local authority certainly, that was the care plan that the local authority was putting forward, and that was the care plan that the local authority says within the judge's mind as far as contact was concerned. Where we say that the judge went wrong, quite frankly, is that if she had ruling out of the mother in her contemplation by the time of the April hearing, when the family placement had not come to fruition with the mother, she should have told everybody that and given us the opportunity to say, well, Your Honour, may I address you?
For my part, it occurred to me when I gave permission, but when I read the papers again this week, it just occurred to me that maybe there was a misunderstanding, that the judge thought there had been, this was, as it were, a set course, and just misunderstood. I mean, it doesn't affect the appeal now.
No.
It's quite striking. It's odd, isn't it?
It is odd, and it's odd for this particular judge because she is very particular and meticulous, and so it's an odd misstep for her to make.
I'm across the judge, of course, and that occurred to me that it may for that reason it may have been a misunderstanding. In which case, well, I suppose when I saw the papers on permission, I might have suggested another course. But anyway, we're here now.
We are, and Bundles, I think that we've all got to take a certain amount of responsibility in that. My understanding is that when it became clear that the judge was ruling the mother out at that 17th of April hearing, no one jumped to their feet and said, well, that wasn't our understanding. May we address you? May we have the matter listed for an hour for there to be argument as far as this point is concerned? I think it's fair to say that everybody was taken by surprise. But just in terms of the procedure, the local authority accepts that the procedure, if we are looking at a fair hearing for the mother, should have been that we were given fair notice that it was in the judge's contemplation, and we should have been allowed to address the court. I don't say that when you look at a North Yorkshire decision, you necessarily have to hear evidence. It can be done on submissions. The difficulty is that we were not even given the opportunity for submissions to be made.
Well, the judge says that there was no gap in the evidence. So, but the mother hadn't given evidence, I understand it.
I understand that, my lord, but when the judge says there's no gap in the evidence, what the judge, my understanding, was referring to was the number of assessments that had been made about the mother's ability to break from the father.
Yes, and that's true. It does. That sentence comes after the sentence in which he says there have been lots of assessments and they don't need another one.
But that sentence also comes against the background where the central issue in this case is domestic abuse and the mother's ability to break from the father so that she is able to say to the court, I've broken from him, I am in a safe place for myself and my child. By the time we came to the hearing on the 17th of April, not only should she not broken from the father, she had actually placed herself in an even more dangerous position in terms of her housing because she'd been rehoused to allow her, as a victim of domestic abuse, to break from the father, but had put the father's name on the tenancy and in fact had moved to a property which was close to two of the other children. And the local authority would say that the judge was correct, the local authority would say, in her decision, but not correct in the procedure she undertook to come to that decision. So if the local authority, for instance, had been told by the judge, I'm thinking of ruling the mother out at this point, address me on it.
Mm.
The local authority's position would have been that you have more than enough evidence at this point to rule the mother out, and the local authority would have gone through in its submissions why it says that. So when the judge says she has no gap in the evidence, the local authority would agree with her. She's got the statements from the mother, 2 statements from the mother, very recent statement where the mother actually admits her dishonesty as far as the father was concerned, admits she is still living in the same house as him. It's within this judge's discretion, particularly this judge, because she has an intimate knowledge of this family. She knows all of the background. She has been the presiding judge in all of the hearings, not only in relation to this child, but also in relation to the 3 older children. So she knows pretty much everything about this family. So good practice in terms of judicial continuity, because we've got a judge who knows the mother and knows the mother well. And the local authority would say that when you look at her judgments and the way in which she speaks about the mother, there is a sympathy and an understanding of this mother's functioning that shines through, the local authority would say, in the judgments of this particular judge.
Now, if we were to allow the appeal, what should we do?
Here is where I depart from Mr. Hatton, and I understand, my lords, why, on the face of it, it can be said, well, on behalf of the mother, how can she possibly get a fair hearing in front of this judge? The reason that I particularly alluded to the judgments of the Honourable Judge early is because the local authority says that she has the ability, even having made the decision to rule the mother out, to give the mother a fair hearing. But it's a question of justice being seen to be done.
Yeah.
And if we are looking at justice being seen to be done, the local authority says we can see the attraction in this matter going before a different judge. But what that new judge will not have is the background knowledge that Judge Early has in this matter.
Well, the new judge will, of course, have Judge Early's judgment in relation to the previous
And the local authority says that a new judge won't be able to, will be able to deal with this matter fairly and hopefully expeditiously. One of the difficulties in this case is that judges in Sussex and probably across the jurisdiction are under extreme pressure. Court time is absolutely precious, and they take the President's words, make every hearing count, very seriously. And the local authority thinks that was very much in Judge Early's mind, probably in coming to this decision. So
We could list a case for a CMH, as Mr. Hatter suggested before Judge Bedford, couldn't we?
yes,
And then he could list it. This isn't going to be an enormous 5-day hearing.
it's not going to
Probably
be
should be a
enormous
1-day
fighting.
hearing.
Yes,
It conceivably might settle.
it
what happens.
It might.
And it surely can be accommodated by Judge Bedford if it's just a 1-day hearing. Either he can accommodate it or bring in a family recorder who can do it.
I know that Judge Bedford will do his utmost to ensure that this matter is dealt with as soon as possible, and that's really all the local authority asks for.
Yeah.
Even if when it goes in front of a different judge, it is listed for 2 days rather than 1 day, the local authority said it probably could still be dealt with around the August date that we have in the diary at the moment. Because of course, if this hearing comes out of Judge Early's diary, she then has time to maybe take another judge's list on that day to allow another judge to hear this matter, and extend it if necessary by a day or a half day. So if it is to go in front of another judge, we do agree that there will need to be a CMH, because another judge will really need to get a grip on the case and steer it in the way that they would like it to be steered. I on behalf of the local authority, it might be helpful, and I don't know whether this was in Your Lordship's contemplation in listing this for an appeal, but this may be the time for there to be some judicial direction as to what judges need to do when a North Yorkshire direction is in their contemplation. It may seem that a judge should know what to do, but that may be helpful at this juncture.
Yeah. All right.
May I assist any further?
Okay. Anything more?
No, thank you.
Thank you very much. Yes, Miss Glaister-Young.
Good morning, my lords. I appear on behalf of the Guardian. The Guardian isn't present, she's abroad, but has provided instructions, and I have the children's solicitor with me in court as well. Your Lordships have identified that the crux really is whether or not the irregularity is serious, so as to make the decision unjust. I'll confine my submissions to that point, if I may. Perhaps if I address the anomaly in the chronology first, when the decision was made. I accept that the Guardian is at odds with the other parties as to when that decision was made. It's clear from the Guardian's position statement, which was prepared for the hearing in April, which your Lordships will find in the supplementary bundle on pages 112 and 113, that the Guardian's view was that the mother had been ruled out as a realistic prospect on the 7th of February. She specifically goes on page 102 to say that underpins her reason for supporting the local authority's care plan to pause the contact. I accept that there is no reference expressly within the judgment from the 7th of February, or indeed the order of that date, to the mother being ruled out as a realistic prospect.
How can it be consistent with the course taken by the judge to allow the local authorities to explore the proposal of a placement with the other couple?
Yes, and as your Lordship identified earlier, there was another assessment ordered on that occasion for the mother with support. That order, in fact, says to live with or be supported by. So it was a very stringent requirement that was being for support that was being envisaged at that time. Arguably, I would say when one looks at the totality of the judgment on the 7th of February, it's very clear that Her Honour Judge Early had looked at the assessments, she had considered the evidence and the arguments that had been put on behalf of the mother, and she had formed a conclusion that the mother was not on her own. She hadn't made the changes that she needed to make, as had been found to be required in the July 2023 judgment. Her Honour Judge Early expressly refers to the judgment from July in February and says, these were the conditions I set, mother hasn't met them. That's when she went on to dismiss the mother's application for an assessment by herself and make the assessment to which your Lordship has just referred. It does muddy the waters in terms of there being a further assessment, but I would say it looks specifically at very clear support that needed to be in place in order for the mother to be a realistic prospect at that stage. That support hadn't materialised by April. I hadn't had access to the April judgment at the time that I prepared the skeleton argument. Having now seen that, the situation is perhaps somewhat more confused in that Her Honour Judge Early says...
You're looking at the note of the April judgment?
Yes, it's core bundle page 38.
38? Oh, yes, indeed, yeah.
And in that judgment, Her Honour Judge Early says, in respect of her earlier judgment on the 7th of February, she was asked to think about whether there should be further assessment of the mother and whether she should care for her child. My Lords, I'm not able to resolve the chronology, I'm afraid. The best I can do is to say that there was clearly a continuum of decision-making from the 7th of February to...
But is she right about that she was asked to think about whether the mother could care for this child as opposed to the other children?
I don't know, I wasn't present. Your Lordships have asked the question, was there a misstep? Was there a misunderstanding? That comment perhaps alludes to there being an understanding on her Judge Early's part that she was asked to deal with that issue. Not being present at the hearing, I can't say what submissions were made or what comments were made in that respect. Certainly Mr Hatton has said very clearly the judge was not invited to make that decision. It may have been an assumption based on the fact that the mother supported placement with Mr and Mrs R, and therefore to some extent the pause in contact, which the Guardian would say was necessary in order to test that placement in terms of being a realistic option at the final hearing.
But the statement in paragraph 2 of the judgment, there was no gap in the evidence.
Yes.
Other than whether O could be cared for by Mr and Mrs R.
Yes.
Is not really correct, is it? Because there was this little, albeit small, potential gap.
With the mother's oral evidence.
Well, no, I was thinking of the proposal that the mother could stay with. The proposal that the mother and the child could live together or be supported by this other couple. That proposal was still alive at that point, wasn't it? The judge ordered an assessment, or the local authority to assess it.
If your Lordship would just forgive my back, I can hear a whispering behind. Yes, in February.
Paragraph 9 and 10 of the order on page 29, the February order.
Yes, in February there was still a prospect of the mother being able to care with support from Mr and Mrs F.
Well, then when the judge says in paragraph 2 of her judgment in April, 4 lines from the bottom of paragraph 2, there was no gap in the evidence other than whether O could be cared for by the R's. Mm-hmm. That's not strictly correct. A, because there was this potential, albeit remote perhaps, and albeit that it's now gone fallen away, and also, as Maud says, the oral evidence.
Not strictly correct insofar as the mother being a carer with support, yes. I endorse what's been said already on behalf of the local authority in terms of the other evidence available, and as I've set out within the skeleton argument, the mother had not been unable to present evidence in the case. She had filed written evidence which comprehensively details the issues.
The mother had not given oral evidence
No.
in this case. One can perhaps understand the scepticism that the judge had about whether she really could separate from the father, but until she heard from the mother, how could it be said that there wasn't a gap in the evidence?
It can't be said there wasn't a gap.
It
doesn't follow that there was...
She did say it wasn't a gap.
She did say there was a gap. There wasn't a gap. I accept there was a gap in that, insofar as the mother's ability to parent with extensive support and living with family members, that assessment was outstanding, or was directed at that hearing. And insofar as the mother hadn't given oral evidence, the items of oral evidence that the mother would have been expected to give are outlined within Mr. Hatton's skeleton argument. For example, practical separation, support that she might have, steps that she would take to protect herself from the father. Those were all in her written evidence. The assessments had been comprehensively cross-examined, as Her Honour Judge early notes within the February judgment. I do accept that the mother had not stepped into the witness box to give that evidence herself.
We've all had cases where one's sceptical of reading the statements, and then when you hear the oral evidence, you change your mind.
Yes. Her Honour Judge Early did have the benefit of having heard oral evidence from the mother before, so she was familiar to that extent with the mother's ability to present her evidence orally, and I understand that was given with extensive support, given the mother had an intermediary. But I accept, in terms, there was clearly a gap. Whether it's sufficient a gap for the court to find that the procedural irregularity was serious to amount to injustice, the Guardian is neutral on that point. Simply raise it in terms of, as set out within the skeleton. But that, I apologise, I can't resolve the chronology more comprehensively, other than to say that there must have been Her Honour Judge Early having had conduct of this case, even in relation to the previous proceedings. There clearly was a continuation of her analysis and decision making in this case. Certainly the decision was crystallised by April. We can see in the order that it was crystallised by April, and I accept that there was no advocate to step forward to ask the judge to determine that issue, and no submissions have been made on any party to do so.
Right. Now, if we were to allow this appeal, what should we do?
The Guardian is in line with the local authority insofar as the Guardian would prefer this matter to stay before Her Honour Judge Early. Essentially, the local authority and the Guardian both say that the decision, whilst the irregularity needs to be examined, the decision wasn't wrong based on the evidence before the court. Her Honour Judge
What about the appearance? We don't like appearance of bias so much these days, but what about the appearance of fairness?
Absolutely. I don't have instructions on that specifically, and of course the Guardian acknowledges, even in respect of the ability to advance oral submissions, that the appearance of justice is important to the mother, and of course it's important to the court. So I don't seek to dissuade the court from that point. I do note that Her Honour Judge Early has had extensive involvement with the case. In terms of the delay, if the hearing can be kept, the Guardian's priority is to keep the hearing if at all possible. I would say, because it hasn't been discussed in terms of the mother's pausing of contact, I can see from the mother's skeleton that it's clear that she views that her case has been impacted by the pausing of contact. As I've said, the Guardian did view the need for those transitions to take place as extremely important, and the order was necessary in order to take that into effect, in order to present the alternative family placement as a realistic prospect for the court at the final hearing. However, the mother has had positive contact. That's accepted within the evidence. It's referenced both in the Guardian's skeleton and within the mother's skeleton. There are further references to the mother's positive contact in the final evidence of the local authority, the Guardian's final analysis, observations that have been made. To that end, I would say the mother's case isn't prejudiced. The benefit of having the case before Her Honour Judge Early is that she knows all the evidence in terms of the contact that's taken place and the mother's relationship with her son, which potentially weighs in her favour. But I accept, in terms of the appearance of justice, that that's a strong point that the court will have regard to. Is there anything else that your lordships wish me to deal with?
Thank you very much. Mr. Hatton, do you wish to reply?
Just very briefly, it's just on a point, I don't want to muddy the chronology any further unnecessarily, but on the point about seeking permission from Her Honour Judge Early directly at the hearing, on the 30th of April, an email was sent by those representing the mother, setting out that the decision to rule her out as a realistic prospect on the 17th of April did come as a surprise. Some brief reasons as to why there was that surprise. Some information saying as to why instruction wasn't able to be taken from the mother at the hearing, which essentially was down to the distress that was caused by the pause of her contact, and inviting the court to list a further hearing if the decision to rule out the mother would be reviewed. It is not without seeking that further clarification that the application for
When I said what I said, I wasn't criticising.
I understood, my
I
lord.
was rather criticising myself for not perhaps mentioning it when I was looking at the papers of permission. But in fact, you had already filed notice of appeal by that point, hadn't you?
Yes, well, because viewing it as a case management decision with the 7-day time limit, it was thought best to get the application for permission in before setting the wheels in motion.
So you asked the judge to review. Was there a response to that?
The ask to review was in tandem with a note of the her decision, her judgment. She approved the note of judgment and didn't review the decision.
Right.
Unless I can assist you further.
All right. Thank you very much. Now, we are going to rise for a couple of minutes, so don't leave the courtroom, just to take stock of where we are and what happens next.
Court rise if able. Be aware the live stream will continue. Court rise if able.
Well, you can all have a very extended coffee break because we're given judgment at 2 o'clock.
Court rise if able.